They agreed to the terms. They don't get to break the contract, and the courts don't get to modify the contracts just because it's convenient and it's upsetting to them that a bunch of people are going to have to leave. And it's not devastating if they knew it was coming or should have known. And they should have known, because Trump didn't just come up with this idea like yesterday.
If each action the president takes, foreign policy, diplomatic, military, national security, has to be individually approved by 700 district court judges, that's democracy?
No,
so if there's
not.
15 communist crazy judges on the court, that each of them as a team working together?
Victory in the Supreme Court again. And one judge in particular is not happy about this. Ketanji, she is dissenting in this after she lost Kristi Noem. I don't think we got a suck it post from Kristi Noem on this one, but might as well, because what happened here is the TPS status, which Joe Biden granted to about 500,000 people, has now been canceled, or at least stayed for the time being. Remember, Trump came in, said revoke, get out. Then all the lower level judges came back down and said, actually, we're the president. You can't do that because it's going to harm immigrants and all these things. You say, that's great. It's temporary status. They have to go back. It was only supposed to be temporary, and now it's time to go. But Trump couldn't effectuate any of his policies until today. But let me show you the final reply that came in from Kristi Noem and the DOJ Solicitor General D. John Sauer. They said, all right, listen, okay, Supreme Court, you know, these TPS status lovers, they repeatedly acknowledge the significance of the parole revocation decision that they seek to stop in its tracks. Right? In other words, Kristi Noem, President Trump came out, they said, your temporary status, your parole in our country is revoked. The people who are saying that, they say, yeah, we know it's a big deal, but we want to stop it. And in that, they barely address the significant flaws in the lower court's nationwide order that said everybody's to stop everywhere, let alone the irreparable harm to the government of a year-plus delay in implementing a decision that Homeland has deemed time-sensitive and critically important. Now, they turn around the TPS lovers and they dismiss those harms as only abstract and generic. They say, well, so what if we got 500,000 people here? You can let them stay here for another 2 years. It's not a big deal to you if they've already broken into your home. In this case, they didn't. It's hard to call them illegal or anything like that because Joe Biden said, oh, you're not illegal anymore. Just come on in. But there is nothing abstract or generic about artificially extending the continued presence in this country of up to 532,000 aliens who may not be here illegally because Joe Biden kind of broke the law to let them in, but they are aliens. They're not citizens. They don't have any permanent status here. So it's time to go. It's called temporary protected status. They have not demonstrated admissibility. They don't have claims for asylum, claims against torture, or any of those things. When the executive branch is constitutionally and statutorily charged with managing the immigration systems, right? It's our job. The president and the executive handle immigration. Congress codified that a long time before President Trump even came into the political field. And we have determined that here there is a national interest, and the judge doesn't get to substitute their judgment for that. They're unelected. This court often intervenes when lower courts usurp the executive's control, and that's what you should do here, Supreme Court, and of course they did. So beginning with the merits, they say the INA, the Immigration and Nationality Act, could not even be clear, okay? It says, quote, verbatim, here, no court shall have jurisdiction to review any decision the authority for which the INA specifies is in the discretion of Homeland Security. So if the law gives it to Homeland, it is Homeland's. You don't get to be a judge who says, actually, I'm Homeland now. The granting and terminating of parole are precisely those discretionary authorities. The INA says the Secretary, Christie, may grant parole to an alien applying for admission in her discretion. Probably says his in the statute, but she's a she. And terminates that parole when in her opinion. It's right there, 8 U.S. Code 1182 D5A. These judges should read it. In his or her opinion. Canceled. Nevertheless, the district court judge purported to exercise jurisdiction over Kristi Noem's termination, said actually, for certain aliens, the people who came from Cuba, Haiti, Nicaragua, and Venezuela, like those illegal Venezuelans who killed that young girl, Ava, in Texas. Echoed by respondents. They say that review bar is inapplicable if the court finds the secretary exercised her authority in an unlawful manner. So he says, well, court said, well, you're right. I can't make a determination on her decision, but I'm not. I'm just going to say she's using the law illegally. So what? That's kind of questioning her decision. No, not the decision about whether to cancel. It's how she's canceling. Okay, so the effect is she can't do it. Under that rationale, a court would exercise jurisdiction whenever it finds the challenged action to be unlawful. That's the whole point of a review bar, right? That's the whole point. You can't just like find another reason. It says it's non-reviewable, so you can't review it. They have no answer for this because there isn't one. Now, in addition, respondents' entire case, the illegals, they both on reviewability and on the merits, hinges on their contention that the secretary may terminate parole only on a case-by-case basis, right? So that's their backup argument. Well, she did it too quickly. She did it too aggressively. It's going to go after too many people. They all have pupusa businesses in America. Now they're going to be in trouble with pupusas in Guatemala. So, but the plain text says that case by case, that applies only to the granting of parole, which Joe Biden didn't do. It doesn't go to the termination of it. Respondents all but ignore the text, other than to observe that the statute does not use the terms grant or terminate. They said it's a non sequitur, it doesn't even follow. Respondents also say that Christie did not terminate the parole. They're saying, well, actually, she didn't really terminate it. She's like, yeah, I did. I signed it. They say, no, she actually just modified a condition of it, which is the termination date, because it was already granted and she just extended it, brought it forward. Now, that is textually untenable and at odds with their own reference elsewhere to the mass revocation of parole, which they said in other filings. So their arguments are changing. Like, wait a minute. You're saying she didn't really terminate it when you were screeching months ago. You said that she was mass revoking everything. So which is it? Now, regardless of whatever they're just making up for their current filings, even when the law calls for individualized determinations, agencies can use categorical criteria. And that's what the secretary did here anyways. So she did. They're all individual. Say, where'd you all come from? Venezuela? Great. Everybody from Venezuela. You all had an assessment. You're all from Venezuela. We've categorically said Venezuela, it's fine. Go back down there to Maduro land and have a great time down there. But we don't have room for you here. So thanks for coming. Actually not. Thank you for leaving. Now, the secretary did terminate parole using those same features, but they all got an individualized assessment. Like, you're from Venezuela? Okay, great. So you're going home. Great. Pack your bags. Respondents have no answer to that point either. Now, instead, the illegal lovers' principal argument is that they will suffer irreparable harm. They say, oh no, if you allow Trump to cancel the status of 500,000 people, he says, wait, because they have not acquired some other lawful immigration status. And if you cancel it, they must either leave the country or they're going to end up in removal proceedings. So either one, they got to go or we'll remove them. They say that's going to be a big deal. And I'll concede that. Yeah, 500,000 people's a lot of people. It's like an entire state in our country called Wyoming. That's why they have to go, because we cannot be importing foreigners to the equivalent of a state like Wyoming. It's not sound policy. It's lunacy. So they have to go. Now, if they were concerned about that, then they should have come, because it's called temporary protected status. So don't treat them like they're morons either. Or I think that's actually what they think. Like, they think that immigrants are just like dumb cattle. I'm not saying that. They think that. And they say, we have to take care of these people, these bleeding heart liberals. We have to take care of them. What are they going to do? They're all going to die unless we act and do something. And it's not our responsibility, quite frankly. So here, the prior administration granted respondents 2-year terms, right? It's their responsibility. They came temporarily. They left their homeland. They can go back and they can manage their lives, just like the rest of us have to do. Now, but the prior administration granted respondents 2-year terms of parole with the explicit caveat that the parole was temporary. You knew it. It was discretionary and it was revocable at any time. So don't tell us that suddenly we're pulling the rug out from all these people. Oh no! It was always temporary. So quit your crying, Ketanji, about how devastating it's going to be to their lives. It was temporary always. Foreclosing their claims of harm. They knew it was temporary. So if there's any sort of like reliance interest that they're going to be claiming, like, wow, we came here, we started a business and all these things. Okay, that's great. Thanks for doing that or for your life. But it's not going to be permanent. Now, respondents underscore their own lack of irreparable harm. They say the district court's order does not prohibit the government from terminating any member's parole or initiating removal proceedings. Yeah. Now, that concession underscores that the district court's order does not actually protect any substantive entitlement. Like, that's what we're asking. What is the reliance interest, right? There's this idea that if the government gives you something, they can't just take it away if you're relying on it. That might make sense. So like the government's like, oh, here, this is your land now, and you can just build on it or whatever. Like, actually, it's our land now. You're like, what? You got a reliance interest because it was handed to you. Now, these are illegals who are not citizens who had their status revoked. So not technically illegal, but you get the point. They're not citizens. They're aliens. And they're about to be illegal if they don't go, as of today. Now, that order instead serves only to throw a wrench into the government's efforts to enforce the immigration laws by confining the government to the gargantuan task of prosecuting 532,000 aliens individually. And that number should just basically disgust everybody. It's a state of people that were flown into our country by the last lunatic administration. A state! The elections are managed by like 50,000 votes in some places, 100,000 votes. votes is dispositive of the entire election. They brought in 500,000 people, and a handful of them are voting in the election. So we know what's going on. Now, Kristi Noem and the DOJ responded to this before the Supreme Court came back out. They say the INA, the law, not Trump's proclamation, not some executive order, the INA, which was passed by Congress and has been in existence forever. Review bar states that with exceptions that are not relevant here, it says this specifically. No court shall have jurisdiction to review this. One more time. No court shall have jurisdiction to review any other decision or action of the secretary where discretion is specified. That's here. The exercise of parole authority plainly is discretionary and it is not reviewable. Now, they don't even dispute that the INA specifies that parole determinations are in the discretion of the secretary. They agree. Instead, though, like the district court, they deemed the review bar inapplicable because she didn't abide by the non-discretionary limits on her authority, which is she's got to go one at a time and say, can I remove you back? In other words, give them all hearings and removal proceedings when the basis of their admission was already temporary. They agreed to come in temporarily. Now they get a bunch of rights to hearings and proceedings and a bunch of due process when they've already agreed it was temporary? No. They knew what they were doing. They don't get to suddenly change their arguments and then say there's a basis to be here forever just because they want to be. They agreed to the terms. They don't get to break the contract, and the courts don't get to modify the contracts just because it's convenient and it's upsetting to them that a bunch of people are going to have to leave. Setting aside that no such case-by-case limitation even exists, it's not required for her to do that at all, it would eviscerate the bar. Under that view, courts would always review the merits of the secretary's discretion to determine whether I can look at it or not. The bar would apply only where the judge says, okay, she did it. It was lawful, right? It's going to be one and the same. If it's lawful, then I can't review it. If it's unlawful, then suddenly I can review it, which is what's happening here. A bar that precludes review only if the court says it's allowed is not a bar at all. Like, the bar has to have some teeth to this. And the proposition that jurisdiction should depend on a court's view of the merits is like an exercise of hypothetical jurisdiction that these courts are not allowed to do. And they have no answers to this. They just say, well, 500,000 people, and we're real sad about it. Now, they invoke on the presumption of judicial review, but that presumption can be overcome by the statute, right? So like, judicial review is the concept that the courts get to say what the law is. Yeah, but Congress also sets the jurisdiction of the courts and says what claims go where. And they have said specifically the courts are barred from decisions like this that are handed to the executive to prevent this from happening specifically. Here, Congress wrote, no court shall have jurisdiction to review. They wrote it. It's about as specific as it gets, okay? They wrote that. Even the INA makes clear that review is precluded where the statute makes it discretionary, and that's what is happening here. They appear to agree that where she makes an individual decision, then that would not be reviewable, right? They say, well, if Kristi goes through and just makes every one of these 500,000 people the equivalent of an entire state, then she can get rid of them. Now, left unexplained is why this decision would become reviewable if it's made alongside 531,999 other people. How come that's different, though? Like, what is your basis for that? So if she can do it for one, why can't she do it for all? Like, show us in the law. Under their logic, had Kristi Noem issued 532,000 separate notices terminating each alien's parole with no explanation whatsoever, that would be reviewable according to their rules. Maybe she'll do that next. Yet same determinations somehow become reviewable under their view because they got combined. But there's nothing in the law that says that at all. Instead, they rely on some other cases that are not applicable, and then they turn around and try to latch onto this with other claims. Then they say, well, it's not really about judicial review and whether she's executing the law appropriately. Now we can also file other claims under the APA. This is ridiculous. The APA doesn't give you judicial review either. You can't use some other provision to suddenly invalidate the law. It says no other court. That means the other claims. It precludes judicial review when an agency has already explained it's discretionary. Now, both of those apply here, and they have no answer to this. They seem to agree that individual paroles can be terminated, but they just say, well, this is really going to be a big problem because it's going out to like our entire voter base. But everything we've done here, says Trump before the Supreme Court got this, is lawful, and we're going to win. Their arguments on reviewability say that we have to go case by case, but that is just plainly incorrect. The law doesn't say that at all. It says case by case for granting it. On the way in, someone should have looked at him and said, do you really need to be here? Are you really in danger? Or did you really need temporary protected status here? Or are you just coming here as part of the invasionary force? Which one is it? They didn't do that. Joe Biden said, come on in, get on an app. Uber illegal into America. Come on in. It contains no parallel requirement for the termination. On the way in, you should look at it. On the way out, you don't have to. And they did the opposite of that, right? They're trying to invert the law. law. Now, respondents never address that distinction because it's devastating to their case, but that difference in the language should be given effect because, Congress wrote it. Now, they say, well, the statute doesn't say grant or terminate, but they say that doesn't matter. It's the meanings. The INA provides the secretary may in her discretion parole. Okay, so it's parole. It's not grant or terminate. She paroled and then unparoled, granted and then revoked. Now, the italicized parole is an active verb. And it's like, okay, you want to mince words about it? It's cancellation of the parole. So then, since they're playing word games, then they try to argue, well, she didn't actually terminate parole, but she just changed the conditions of it, and they get very squirrely there. But the mere fact that the statute is phrased in the singular doesn't, like parole, like such parole of such alien, doesn't mean that it's a singular statute. Respondents observe, they say, well, context is key. And they say, hello, yeah, read it in context. It's in our favor. As longstanding regulations confirm, the secretary may employ categorical criteria in making parole determinations. You can look at the Code of Federal Regulations right there. Nor do the TPS lovers address the problem that their incorrect reading of the statute would say that Congress insertion of the case-by-case language, it would be meaningless. And we're not supposed to make things that Congress wrote meaningless because that's the law. Courts should require language to have effect. Now, even if the statute imposed a case-by-case requirement, we did it. Even where Congress says, okay, make individualized determinations, we can do that. Why? Because the categorical criteria here, oh, okay, your Venezuela, your emergency, whatever the justification was from Biden is now over. You can go home and you all have already been in the systems in these correct categories. So your cases have already been reviewed individually. We don't need to review you again individually to say, are you really from Venezuela? We already know that. Indeed, it would be strange to fault the secretary for terminating parole by applying categorical factors when literally Mayorkas Alejandro granted parole by applying categorical factors. It said case by case on the way in. He didn't do that. He said, just get online, get on an app, we'll pay for it, come on in, because you're in danger. Says respondents, the TPS people, say that Nome recognized that potentially eligible beneficiaries were adjudicated on a case-by-case basis, but that's missing the point. To receive parole, they did have to satisfy both the categorical criteria from Mayorkas and individualized criteria, because that's what the law said. A failure to satisfy either would have resulted in a denial of parole. So Nome and her determination to say, well, the criteria no longer justifies their parole is valid the opposite way. Now, these situations are common. Happens a lot. A lack of detention capacity, or the fact that there is people who might be a danger to the community. We categorically treat people in categories all the time. But once a new detention facility becomes available, the purposes of parole would have been served for all the aliens who were then paroled because of a lack of detention capacity. So, okay, we can't hold them anymore, so now we got to do something. This is why it was ordered to be granted by Congress on a case-by-case basis, but to permit parole to be terminated on a categorical basis. It would be pointless and illogical to require the secretary to additionally and redundantly make a case-by-case determination before terminating them on the way out. Like they already had their determination on the way in and agreed it was temporary. Now it's canceled. Now you go. You don't get to come file a bunch of additional claims here. You already knew it was temporary. In all events, given that the secretary will continue to exercise her decision on a case-by-case basis in the categories, her rejection of the categorical criteria does not violate their incorrect reading of the statute. And like the judge below, none of this is arbitrary and capricious. They say, how dare you do this to 530,000 people? They say she acted arbitrarily in terminating this, but we observe that the law says Homeland may subject a non-citizen to expedited removal only if that person has not been admitted or paroled. And they say, well, that is just in the past. So it's like if you were once paroled, then you still can't have removal proceedings, is what their argument is. That's obviously incorrect. As a purely grammatical and linguistic matter that they don't understand, apparently, of course, the present perfect tense could refer either to a single past event or to a continuing status. So it's like, well, if they ever had parole, then you can't remove them. And they say, that's not what it says. It says if they don't have parole, then they can be removed. And that's at the current time, not anything in the past. Respondents say that parole is paired with admission. And so we're now talking about text and grammar, but the INA lacks any provision about this. Those regulations say after parole is terminated, get out. But here is what they say in terms of the equitable factors. Okay. And when we talk about equitable factors, we're kind of balancing the harms. Think about it that way, like a little balancing scale. Well, what happens if we do this? So it's going to go this way. What happens if we go this way? So we're going to deport 500,000 people. It's going to be a big deal. I think it is going to be a big deal. That's the point. The district court's order imposes irreparable harm on us, the government. Now, and the people whose interests merge here. Okay. They're one and the same. The Constitution Constitution and the INA grant the Secretary, Kristi Noem, and the political branches, not the courts, the task of deciding whether it is in the public interest to allow 532,000 aliens who were never admitted or inspected to remain in the country. I don't think it's in our interest to have 530,000 foreigners from foreign countries floating around our country in a temporary status on the road to be permanent citizens, or whatever they want to categorize them as. We are tired of the invasion. And the Secretary discharged that responsibility at length, explaining why the CHNV parole programs and the specific foreign policy approach that justified the creation of those programs are antithetical to our foreign policy. Now, they say those aren't really harms. So what, Rob, if you have your country invaded by everybody else around the world, and if your people are not seeing their wages increase, not seeing the ability to buy homes, not seeing the ability to find good jobs, having our life expectancy dump in the toilet, and life goes on, but just deal with it because we have a responsibility to care for everybody on the planet while our country's being hollowed out. No, they call those harms abstract and generic because to them, the illegals who are non-citizens are more important than you. Now, they ignore the concrete specific harms that result from forcing the executive branch to tolerate the presence of 532,000 aliens whom the Secretary has determined should not remain in the country. Now, as Kristi explained, any delay in terminating these parole programs would undermine our ability to conduct foreign policy, shift government policies, and impede time-sensitive negotiations. And beyond that, the executive branch suffers harm when the district courts intrude on the core executive functions, which is what's happening here. Now, they then try to turn this around and say, well, the district court's order is very narrow. It says it doesn't prohibit the Secretary from terminating or truncating the class members' parole. Remember, they all got class status too because they're better than us. Or prevent the federal government from terminating the parole of any individual beneficiary. But they said there's no practical way for the government to proceed individually. You want us to have hearings for 500,000 people in a reasonable time frame? No. And least of all, because the effect of such delays might well require a greater proportion of this population to be placed in ordinary rather than expedited removal proceedings, which is straining the system already. Put simply, the order is inimical to the government and to the public's strong interest in removing these people now. Now, on the flip side, a stay of the lower court order is not going to cognizably harm the respondents or the absent class members. As Mayorkas repeated when establishing these very parole programs, he told them, parole is a discretionary benefit that can be terminated at any time. He wrote it. He said, quote, DHS may terminate parole in its discretion at any time. They were on notice. The fact that they didn't believe it, the fact that they didn't care, the fact that they thought that this was going to be Disneyland in America for the rest of their lives is their problem, not ours. Respondents contend that a stay of the district court's order would put many beneficiaries immediately at risk of deportation without normal due process protections. It's like they came in under an agreement that they would leave at any time, and now they want due process about that? That is incorrect. As the government has explained, parolees who lack 2 years of continuous presence and cannot establish admissibility likely would be placed in expedited removal anyways, which comport with the Constitution and the Due Process Clause. Now, they assert that they may be removed to countries where they're going to face risks of danger and persecution and even death. But any alien placed in expedited removal proceedings could raise claims under the Convention Against Torture or other withholding of removal protections if they think they have those. But fundamentally, their repeated assertions that the order does not prevent the government from terminating parole underscores that they are not protecting any substantive entitlements. They don't have any rights to be here, period. They came here temporarily. Instead, the order simply serves to stymie the government's efforts to enforce the laws that they already agreed to, and that is not a harm. They can't claim harm for doing what they said that they would do, much less one that outweighs the government's strong foreign policy interest in implementing the discretionary judgments that Congress entrusted to Homeland. Banger filing right there. D. John Sauer, Solicitor General, coming in to the Supreme Court. And that was effective because the Supreme Court came back down and Trump wins on this one. From the Supreme Court, a very short order, 7-2. They write in the Kristi Noem case, TPS status is canceled again. Says the application for a stay, Trump said, okay, Supreme Court, can you stop that lower judge? He said, we can't cancel this. Can you stop him from canceling our cancellation? Referred to the court through Justice Jackson is hereby granted. Victory. The April 15th order that was coming from Massachusetts is now stayed pending the disposition of the appeal in the First Circuit and the disposition in this court if it is sought. lot. So if the First Circuit gives a bad ruling, the next party will take it up to the Supreme Court. The Supreme Court can decide what to do with it. If they deny that, then that means they're happy with the First Circuit Court of Appeals, and that can stay. If they're unhappy, if it is granted, then the stay will be in place until the Supreme Court decides. So as it stands, TPS status is now canceled again. And so Trump is victorious. The American people are victorious. The idea that we have to just have 500,000 people get Ubered into our country and stay indefinitely is not in alignment with the law. And the Supreme Court found accordingly. Now, this was 7-2. You can see we've got two people dissenting down here. We got Justice Jackson, with whom Sotomayor dissents. Let's see what they are crying about. Now, we notice that Kagan is going to be up in here. So shout out to Amy Coney Barrett. Thank you to John Roberts for coming out on the right side on this. And thank you, Kagan, for also eschewing your liberal ladies and joining the right side of the law. So here is what Ketanji had to say. When this court evaluates whether or not to stay, the factors we apply are well established. Okay, all right, so she's going to make it a procedural objection. Normally we are a lot stricter before we accept stays or not. In any given case, each of these considerations talks about the appropriateness of what we should do. So basically, the Supreme Court internal procedure wasn't rigorous enough in granting this. Here's what Ketanji says. Oh, Ketanji's big bad. She says, the court has plainly botched this assessment today. Oh no, Ketanji. It requires next to nothing from the government with respect to irreparable harm, and it undervalues the devastating consequences of allowing the government to precipitously upend the lives and livelihoods of nearly 500,000 non-citizens while their legal claims are pending. Yeah, they are non-citizens. They're aliens here from a foreign country. And it's interesting. It's like she really cares so much about their lives, and I guess is not so concerned about the upending of their lives temporarily to come here. They were willing to do that. They changed everything, left everything behind to come here temporarily, agreed to it. Now they can go back. Like, in other words, they're used to it. And it's not devastating if they knew it was coming or should have known. And they should have known, because Trump didn't just come up with this idea like yesterday. Kind of been running on this issue for a long time. So if you're here on TPS status and it's December 2024 and you just saw what happened in November and you're not packing your bags, well, that's on you, bro. Now, even if the government is likely to win on the merits, in our legal system, success takes time, says Ketanji, and the stay standards require more than anticipated victory. She's like, I just want to buy him some more time. Ketanji says, I would have denied the government's application because its harm-related showing is patently insufficient, right? She says, it's not a harm to you, America. It's not a harm to you, government, to have 500,000 people, an entire state, literally Wyoming. It's like 550,000 people in Wyoming. Beautiful state. Now, the balance of the equities also weighs heavily in the respondent's favor, says Ketanji, in favor of the TPS people. While it's apparent the government seeks a stay to enable it to inflict maximum pre-decision damage, she's mad. Maximum damage. Court-ordered stays exist to minimize the harms. Nearly 500,000 Cuban, Nicaraguan, Haitian, and Venezuelan non-citizens have invaded our country. On January, Trump said, get out, and they sued. They have a putative class action. They got pseudonyms. They got everything they wanted. They got ACLU lawyers and more. She says this decision does not reflect a back-of-the-napkin assessment. She says the dilemma is pretty serious and there's going to be irreparable harm. Notably about stays, the bottom line is this. Our decision to issue a stay involves much more than merely forecasting. We also have to talk about the harms. Here we go. The government plainly failed to satisfy the harm, saying having 550,000 people is not a big deal to us. Just shove it, eat it, just deal with it. I'm Ketanji. Homeland contends that the district court's order prevents it from doing its job as a general matter, but it doesn't establish an urgent need to get rid of these people now, right, Ketanji? Now? Why are you doing it now? Because we got a lot of people to get out. We're not wasting any time before the courts can determine whether an action is lawful. So she just wants more time, right? So just drag your heels, put some speed bumps in the process and whatever. Now, for instance, she said the agency doesn't identify any specific national security threat. It's like, well, like they're not going to like blow up Washington or something so they can stay. If they're not going to commit 9/11, then they can stay. So yeah. And there's also no specific foreign policy program that Ketanji's happy about. And they can also do it on a case-by-case basis. And so there's no harm to them. They should wait. The government should wait. They've already been here long enough, so why not wait? But now they're going to have all this harm. This is where liberals just go bananas. Respondents have shown that imminent and significant harm is going to befall them if 500,000 people have to go. A stay would immediately effectuate, this is what they did. The Supreme Court just granted this stay. So like this is a checkbox. Okay, so all this is going to happen according to Ketanji. Incredible. What's going to happen right now? En masse truncation of all parole grants for 500,000 people. Many parole recipients arrived here at the invitation of the US government. Yeah, which was scandalous and treasonous. That's my point, right? The illegals shouldn't be mad at Trump or Republicans. We want to take our country back. Quite frankly, the illegals should want to take their countries back too. They should go back down there and make it so that it's not a terroristic hellhole that they want to flee. So the government brought them in and basically set them up, rug pulled them by promising them something that was never deliverable unless the laws were broken. So because their home countries were afflicted by strife, which again, I'm sorry it's afflicted with strife, but do you know what we have in America? Strife. We all have strife every single day. Lots of strife that we all go through. Doesn't mean we get to break the law and go to a country that we deem better for us automatically and then have judges lecture us about accepting them. Or they're subject to unsafe living or working conditions. Yeah, we got that too. Now, parolees have sponsors here, and in many cases, they've already integrated into American neighborhoods. That's the point. And communities in hopes of eventually securing long-term legal status or asylum, which was the game plan that we're canceling. No one disputes that social and economic chaos will ensue if that many non-citizen paroles are suddenly and summarily remanded. Well, I mean, I think that there will be probably some economic chaos, probably for the 500,000 people and their businesses and all of those things. I would imagine there will be some, I'll grant that. But the invasion of our country to the tune of 20 million people, or 10, pick a number, I don't care, is causing economic chaos in our country, Ketanji. So you have to pick one. You have to pick an option. Which road? Do you want to have a country that has a border and a functional citizenry with sound economics where we can have real jobs and not hollow out our industry? Or do we want to be this globalistic world where everybody can come in from all over the place for whatever reason because they're experiencing strife on the way to the grocery store? There are consequences to this, Ketanji. Just because you don't care about them because you're in Washington, D.C. and you don't have to see it doesn't mean it's not real. So now they say the respondents, the temporary aliens who always knew they were temporary, they now face two unbearable options. On the one hand, they could leave the United States. That would be great. And then they would confront dangers in their native countries. Or they could experience family separation. Or they could forfeit any opportunity to obtain a remedy based on their other claims. Well, you know, they're adult people. They're humans. They got functional brains in their heads. So how come they couldn't come to these, conclusions when they were here temporarily? Like if you go to a student visa, like you're going to go get a visa to Oxford or something, like, unless you plan and have a plan to stay forever and the law allows that, it's temporary. Everybody knows that. So it was the same thing here. And now all of these consequences for something that was from the very beginning temporary. On the other hand, they could remain in the United States after parole, or they could risk imminent removal. Government agents are going to come round them up, along with serious attendant consequences from that. Saying, yeah, even confirming, yeah, if you don't leave, respondents may be subject to arrest and detention and will no longer be authorized to work here legally in this country either, and will lose opportunity to seek any adjustment of status. It's all canceled. Yes, that's the point. We won the election. All canceled. The opposite of what Joe Biden did. Now, either choice creates significant problems for them, and it's not enough harm to the government. Both options might deprive this court of jurisdiction, and so we should grant a stay. Because if we do, granting the stay would facilitate needless human suffering before the courts. And I guess Venezuelans who are here illegally killing American citizens like Eva from Texas, who is a U.S. Air Force cadet, that's not really human suffering to them. So our totally wide open system that was enabled by Joe Biden can allow to persist even after they got obliterated in the election, saying this is going to have high stakes, says Ketanji, real harm to people. One might reasonably expect the government to step up to equity's scale with a mountain of harm-related arguments bolstered by evidence. But the government is not showing why anyone's going to be harmed and why we need this policy now. Well, we need it now because the delay is the entire strategy. The lawfulness of this agency action is being litigated. We've denied other stay requests before, and the government is not giving us enough here, saying, and I suppose, I guess she says, somehow the court has now apparently determined that the equity balance weighs in the government's favor. And I suppose, says Ketanji, that it is in the public's interest to have the lives of 500,000 aliens unravel all around us before the court decides their legal claims. She supposes, yeah, they didn't phrase it as kind of like a hysterical person. 500,000 migrants unravel all around us. Even assuming a likelihood that the law permits the government to terminate this, I will let the courts decide the highly consequential legal issue first, but allowing the government to do what it's doing now is unleashing devastation in the process. All right, yeah, well, the illegals illegals have devastated our country, and the politicians who enabled it have done the same. And now we reverse the course of power here, and we're fixing what they've done to us. So that was quite enjoyable. Ketanji was roaring mad because they care about illegals more than their own country. Now, we have Stephen Miller not playing around. Stephen Miller went on to CNN and spoke with Cassie, last name Hunt, and here is what he said during this very enjoyable obliteration.
Last few weeks, yet even just yesterday we saw whenever a judge rules against this administration, you say they're going rogue. Do you think a judge should just rubber stamp what your White House does? If not, what checks and balances do you think should be in place for this White House?
It is not the job of a district court judge to perform an individual green light or red light on every single policy that the president takes as the head of the executive branch. Just think about the premise baked into your question. Respectfully, Pam, you're saying that when the American people elect a president of the United States of America,
I'm not saying that.
Well, it's the implication. Who is the sole head of the executive branch?
Said,
well, let me finish. I will
place?
answer the question happily. But look, when you have these kinds of lazy assumptions built into questions, it makes it hard to have a constructive dialogue.
What is a lazy assumption? I said you all had to win.
You said is it my expectation?
I'm speaking because now you're putting.
You said is it my expectation? It's not just you. It's the whole media. In other words, when you
I know
hear
you
a
want
sentence
to loop
like
us on. It is a completely fair question. You say judges who rule against the White House
and I will
go rogue.
gladly answer it. When you say, do we think district court judges should rubber stamp each action? There is a premise that is built into that is absurd. The president is the sole head of the executive branch. He's the only officer in the entire government that's elected by the entire American people. Democracy cannot function. In fact, democracy does not exist at all if each action the president takes, foreign policy, diplomatic, military, national security, has to be individually approved by 700 district court judges. That's democracy.
No,
so there's
not.
15 communist crazy judges on the court that each of them as a team working together can block and freeze each and every executive action. Joe Biden was allowed by that same court system
Some of them
to
are Trump
import 20
judges,
million
though.
illegal foreigners.
Why did Trump
into
put
this
these
country.
crazy communist judges, as you call them, on the bench?
You heard President Trump himself say that the Federal Society and Leonard Leo has created a broken system for judicial vetting. And God knows this time around, we are not going to be using...
So does that mean he doesn't support picking Amy Coney Barrett for the Supreme Court?
What it means is simply this and nothing more. We're not going to be using the Federal Society to make judicial nominations at all going forward.
Yes, and my apologies, notice of errata on that. I thought that was Kay, last name Hunt, but it's not. I guess it's Pam somebody from CNN. They all kind of look and sound the same, so sometimes I get confused. But Stephen Miller is exactly right. These judges are instituting a judicial coup, and thankfully the Supreme Court on this case has come out and said status is canceled.